At the scroll of your name, please.
My name is what you asked
Yes.
for?
I did.
No, I'm not Peyton Ansley John Milton. I'm the agent authorized to represent Peyton Ansley John Milton as written in all capital letters.
All right, buckle up, because this is one of those courtroom appearances where reality checks get handed out in bulk. Today's case is a perfect storm. A self-declared sovereign citizen, a trespass charge, alcohol, and a judge who has absolutely no patience for word salad masquerading as legal theory. From the jump, you hear the classic sovereign citizen playbook. I'm not that person, I'm an agent, capital letters, imaginary entities, all while standing in front of a court that deals in facts, not vibes. And here's where it gets interesting. This defendant doesn't just deny responsibility, he openly admits to the conduct and argues he was too drunk to be accountable. That's not a defense, that's a confession wrapped in delusion. As this hearing unfolds, you'll watch a judge calmly dismantle pseudo-legal nonsense, explain actual law in plain English, and repeatedly give the defendant opportunities to help himself, opportunities he enthusiastically wastes. Pay close attention because this case is a masterclass in how confidence without competence becomes self-sabotage in real time.
And as to Mr. Milton, is there a competency concern, or is this
I am not represented by anybody besides myself in my sovereign capacity. Appreciate you.
Thank you, Your Honor. I did have an opportunity to speak to him. I read him the reports. Who
is him?
Don't interrupt. I'm letting you just sit quietly.
Thank you.
I read him the report so that he will understand the charges against him. He didn't wish to hear anything more about his rights, and he does not wish to be represented. Thank you.
As the agent for Peyton Ansley John Milton, you are indicating to me that you're quite familiar with Peyton Ansley John Milton, and that's basically you. Is that correct?
I am the agent authorized to represent Peyton Ansley John Milton as written in all capital letters.
All right. And you understand, for my purposes, though that language doesn't make any sense. So
no, I do not.
I understand. Okay. Well, I'm telling you that. And so I am, until you disabuse me of the motion or the notion, I am inclined to believe that you are both the agent and the person. So, and it's an all
I'm not
caps,
a person. I am one of the people.
This right here is peak sovereign citizen theater. The defendant insists he's merely an agent for a name written in capital letters, as if fonts somehow change jurisdiction. Courts have heard this exact argument thousands of times, and the outcome is always the same. It fails immediately. Judges don't play along because the law doesn't recognize fictional legal avatars. What makes this moment especially telling is how patiently the judge explains something incredibly basic. That if you're standing there answering questions, you are the person before the court. No metaphysics required. The defendant's attempt to redefine person collapses under a literal dictionary definition, and the judge doesn't sugarcoat it. This exchange sets the tone for the entire hearing. The court will tolerate speech, but it will not indulge nonsense. And once the judge makes a finding for the record, that door is closed. Sovereign citizen arguments don't create mystery, they create credibility problems.
Okay, thank you. All right. So for the record, that's my finding. Yeah, hold on, we're not done.
Okay.
Have a seat.
You got it.
And thank you. Mr. Sharp, let me swear you in. Swear the testimony and probable cause application will be the truth, whole truth, and nothing but the truth.
I so swear, Your Honor.
Okay, Mr. Sharp.
So this information comes from a report of Officer Evers of the Lacey Police Department. She responded to an unwanted person complaint at a 7-Eleven store. Upon arriving, Officer Evers contacted staff who advised her that it was a white male, approximately 5'5", with a beard, wearing green long-sleeved flannel. Staff advised that he was intoxicated and belligerent. At one point, the male stated he would be waiting outside when they got off work, that they asked the male to leave multiple times and he refused. Once they called the police, the male returned to his Toyota 4Runner, that it was parked outside the gas station. Staff stated that they didn't feel safe, wanted the male trespassed. Officer made contact with the male and immediately was able to identify him as Peyton Milton. Officer knows Mr. Milton is a local transient that lives out of his car, has had several social contacts with him. Officer Evers asked Mr. Milton if he was just inside the store. He stated that he was. He stated that he was too drunk to be held accountable.
Let's pause here because this is astonishing. The defendant openly admits he was intoxicated and uses that as his primary argument for why the law shouldn't apply to him. That's not how criminal responsibility works, at all. Voluntary intoxication is almost never a defense for basic crimes like trespass, and in this case, it actually strengthens the state's position. The officer's report makes it clear. He was intoxicated but functional, understood instructions, and was explicitly warned not to return. Not once, but twice. And he still went back. The staff felt unsafe. That matters. Trespass isn't about hurting someone. It's about refusing to leave when you're lawfully told to go. Saying "I was too drunk" doesn't erase intent when your actions show comprehension. This moment isn't just legally weak, it's strategically disastrous. He's handing the prosecution proof on a silver platter.
Officer advised Mr. Milton that he'd be trespassed from the 7-Eleven, and he stated, "I understand what you have to do." Mr. Milton offered to manually push his car to a gravel lot about 25 yards from the 7-Eleven so that he wasn't on the property, since he was too intoxicated to drive. Officer agreed and gave Mr. Milton until nightfall to push the car out of the lot. Officer provided Mr. Milton with his phone, and he replied, "Can I go back in and charge it?" The officer advised him that he could not charge his phone at this 7-Eleven and that if he entered the store again, he would be arrested. Officer provided Mr. Milton with a copy of the trespass form. And then at 16:23 hours, staff called dispatch advising that Mr. Milton was back inside the store. Staff advised that Mr. Milton said he was too drunk to be held accountable, and that he left again once they called dispatch, and this time he again left his cell phone in the store. Officer then contacted Mr. Milton. He again stated that he was too drunk to be held accountable. Officer noted that Mr. Payton was intoxicated but functional and able to understand the officer's instructions. Officer advised Mr. Milton that he was under arrest for trespass, detained him without incident. He was then booked into the county jail. The Squally jail.
On the charge of criminal trespass first degree, is the city making a motion to revoke the deferral on the assault conviction or
Yes,
on the
Your
assault case?
Based on the new law violation, yes.
Thank you. And let's see.
Now, will I get a moment here to articulate anything?
This is one of the most important sections of the entire hearing, and honestly, it's where the judge shines. The court goes out of its way to protect the defendant's rights, explaining clearly and patiently that self-representation is almost always a terrible idea. This isn't condescension, it's experience talking. The judge explains exactly what will happen. Missed motions, procedural mistakes, arguments that backfire. And crucially, the court reminds him that free counsel is available. This isn't coercion, it's due process done correctly. Yet the defendant, armed with internet myths and misplaced confidence, declines. What people don't realize is that once you knowingly waive counsel, the court is no longer obligated to save you from yourself. The judge has now created a clean record. Any disaster that follows? That's on the defendant.
I'll let you know. So sit
Appreciate
tight.
it.
I'm still working through the process. Thank
Of
you.
course.
All right. So, Mr. Sharp, it appears that the assault was not a deferral. It was a stipulated order of continuance.
That's correct, Your Honor.
All right. Thank you. So we'll note the city's motion to revoke the continuance on the assault charge based on the allegation of a new law violation. And Ms. Langley was counsel of record on that case. Well, I will, and Mr. Milton is asking not to be represented by counsel. Is that correct?
That is correct, Your Honor.
Okay, so let's have a little chat about that. If you choose to represent yourself, which is your right, you can make that choice. But I want to make sure that we make a record that you are doing so knowingly and voluntarily. Ms. Langley is an attorney. I'm going to guess that you have not gone to law school and become a member of the bar. Is that correct?
I can neither confirm nor deny that information, actually.
Here's where legal misinformation really does damage. The defendant is obsessed with Miranda rights, treating them like a magic spell that prevents charges from existing. That's simply wrong. Miranda protects against self-incrimination during custodial interrogation. It does not invalidate an arrest, erase evidence, or stop prosecution. The judge explains this correctly and carefully, but notice the subtext. The court cannot coach him. A defense attorney would already know how to request discovery, body cam footage, and suppression motions properly. Instead, the defendant is improvising in real time, confusing constitutional law with YouTube slogans. This moment perfectly illustrates why courts beg people not to represent themselves. Knowledge gaps don't just weaken your case, They actively strengthen the other side's.
So not being an attorney, you understand that if you represent yourself, the court cannot assist you in recognition of the fact that you're not an attorney. So you will end up missing things you're supposed to do. You will do things you're not supposed to do. And all of those things will likely work to your detriment. So it is never a smart thing to represent yourself. And frankly, if an attorney were to say they would represent themselves, I would have the same conversation with them and advise them, I think it's a foolish decision to make. You, however, have that right, as I pointed out. But I want to make sure you understand you have the right to have counsel. You have the right to have me appoint counsel, or you can hire counsel. And if you ask me to appoint counsel, I can appoint counsel at no cost. So you understand all of that.
I appreciate that, and I do. Thank you.
And how do you choose to go forward?
Pro se, please.
Okay, you even know the right term. Okay. All right. I won't appoint counsel to represent you. You'll have to represent yourself on both cases, the criminal trespass charge and the city's request to revoke these continuance and get a conviction on the assault charge. So that's at risk here with this new allegation. So I want you to be aware of that.
Your Honor, I was not read my Miranda rights this most recent time. I believe I'm supposed to request a voyeur of the body cams.
This exchange is painful to watch. The judge gives a clear, narrow instruction: argue bail only. And instead of focusing on ties to the community, flight risk, or ability to pay, the defendant launches into unrelated grievances, alleged thefts, and past encounters. None of it helps. Bail hearings are about risk management, not storytelling. The judge even tells him, plainly, that this was his one shot and he missed it. This is where preparation matters. A lawyer would have made a concise, targeted argument. Instead, the defendant talks himself into continued detention. Courts don't fill in the blanks for you. If you don't advocate effectively, the decision still gets made, just not in your favor.
Like I said, I can't represent you. You're going to have to figure all that out yourself. For purposes of today,
I'll require 4 to 6 hours of unhindered internet access so that I can properly represent myself. If you would write that into a court order.
Read your form on your constitutional rights.
Did I read my form? I don't believe I was provided anything.
Okay. Is there a corrections officer there?
Mr. Upton?
Yes, Your Honor.
Let's present Mr. Milton a copy of the rights form and have him read it. And then he and I can talk about it.
Yes, Your Honor. There's one taped to the desk right in front of me.
Okay. Why don't you take a minute and read it? Let me know when you're done reading it, Mr. Milton.
Appreciate you. I haven't been Mirandized, so it's hard for me to even start since I can't technically be charged with anything. And there's no victim in this alleged crime.
All I'm asking right now is for you to read the rights and tell me that you have done so.
All right. Would you please silence yourself? Forgive me.
And actually, Ms. Langley, if you'll unmute, because I have some questions for you regarding other cases.
Several days later.
I have completed the reading, sir.
All right, thank you. I'll talk about that with you in just a moment as soon as I finish this document I'm working on.
Thank you.
Any question about those rights or on that form?
Not particularly.
Okay, thank you. All right, so the question before the court now is whether I'm going to hold you on bail. The city has asked for $500 cash or bond on each case. Just address that issue. Don't address the underlying facts, because to the extent that you do so, any statement you say regarding that can be used against you on these cases. So right now, just address the issue of whether you should be released or not.
Appreciate you. Yes, I would like to request being released on personal recognizance. And the reason being is because there were several things articulated in the statement that were absolutely not true. For one, I was not in possession of a cell phone. No worries. I was not in possession of a cell phone, as I had my vehicle, my phone, my computer, my passport, and every physical possession stolen from me last time I was under arrest for defending a senior citizen in this community. The same day that Officer Tittle refused to search the man who stole my key.
Okay. Anything else?
That's it for now.
Okay.
This moment would be funny if it weren't so revealing. The defendant confidently misunderstands basic bail math, assuming impossibility where none exists. And again, the judge corrects him, calmly, professionally, explaining how bond percentages actually work. This pattern repeats throughout the hearing. The defendant asserts something with certainty, and reality immediately contradicts it. Legal systems don't run on feelings or assumptions. They run on rules. What's remarkable is how many off-ramps the court provides. Even now, the system bends slightly toward fairness. But fairness still requires competence, and competence requires preparation, or counsel.
Unless you would allow me to fill in some details that they failed to read me my Miranda rights, and I wasn't taking a statement from in both questioned cases in question.
All right. So what the case of Miranda tells us is that if you make any statements while under arrest prior to being read your Miranda rights, the prosecutor is limited in its ability to present those statements to the court. It doesn't have any other purpose other than whether something you say can be used against you. That's the whole purpose of Miranda. Doesn't mean they can't go forward with a criminal charge.
Oh, I was never aware of that.
Right. Which is one of the reasons don't want to represent yourself, but I've explained that to you now. But I just want to make sure. So you still wish to represent yourself?
Absolutely.
Okay. All right. Seem like a sharp guy. So
This case is a textbook example of how pseudo-legal beliefs collide with real-world consequences. The judge did everything the law requires, and more, by explaining rights, offering counsel, correcting misunderstandings, and maintaining control of the courtroom. The defendant, on the other hand, chose ideology over strategy, confidence over competence, and spectacle over substance. The result? Bail imposed, charges moving forward, and a clean record that will hold up on review. If there's one takeaway here, it's this. Courts are not debating clubs. They are structured environments governed by rules, and ignoring those rules doesn't make you free. It makes you vulnerable.
Appreciate you, Your Honor.
seem dedicated to it. Okay. Based on the outstanding warrant out of Skagit County, I will hold in $500 cash or bond bail on each case, total $1,000 cash or bond. And I'll remind you, you're to have no contact with the 7-Eleven store, no criminal law violations, not consume any alcohol, marijuana, not enter any bar or tavern. And give me some realistic expectation. Are you going to be able to post bail or likely not?
You know, if the minimum that I'm allowed to throw on a bail is 300 and I have to bail out for two things, then I'm certain I would need to acquire a phone number that I don't have in order to make that happen. And so I would have to say that it may be closer to impossible this time around.
Okay. Well, you may know from your history that the bail here is usually 10% of what's ordered. So $50 on each case is what a bonding company would want from you. So just, I don't know
Cool.
whether that
Well, I have
changes anything.
$100. Isn't that
Okay. All right. Thank you. I will set this for 3 weeks from today at 1:30 in the afternoon. So on Monday, the 24th of April, for what we call a pretrial, Mr. Milton. And at the pretrial hearing, you will have received information from the city prior to that as to any offer to settle the case. Just so you know, you don't have to accept it. But they will be contacting you to give you whatever offer they have. And then you'll tell them, the court at that time, whether you wish to accept the offer and enter whatever arrangement is made, or whether you wish to go to trial. So that'll be what we discuss on the 24th.
awesome? In the meantime, will I be allowed 4 to 6 hours of unhindered internet access so that I can represent myself?
Yeah, I do not regulate the jail. So you're going to have to talk to the folks at the jail.
If you write it as a court order, I'm certain that they will be more likely to comply than if you don't.
All right, I'm not going to write it as a court order. Like I say, I don't mess with how the jails run their jail, but
Speaking of, by the way,
Mr. Sharp has heard you, and we'll go forward that way.
on a side note, if I may, Your Honor, during intake, and I might preface this with, I have gone to anti-kidnapping